And then I'm also going to post an attendance register that I'd like you to complete. And towards the end of the session, please complete the feedback form, because we value the feedback in terms of what your needs are and what you expect of these sessions. Okay. So just as an introductory, what we normally do in these sessions is we keep all microphones and cameras on mute and camera off. So it saves data for yourself, and it also improves the quality of the broadcast. And then also remember that these are not tutorial sessions. So they are open, they are free, and we would like to see a facilitator focus on the skills that you need in this law subject to be able to pass or master the module. So please feel free to participate, to ask questions, to say, you know, you must feel free to say to Rayan, there was a question in one of your assignments, or you see a question in an assignment, please can you just have a discussion about it? So it's more interactive sessions than sitting listening to a lecture. Okay. Rayan is a very experienced tutor and facilitator, so he comes with a lot of practical knowledge. He has his own practice as a lawyer, and we are very, very fortunate to have him to also do this module. If there are any of your other law modules that you find really challenging, please put that in the chat section as well. In case we don't offer sessions for that, we can't promise anything, but we can always have a look at how we can support you. Just once again, don't forget, I'm going to post the attendance register now. Please fill that out, and then also the feedback form at the end of the session. Okay, Rayan, over to you.
Thank you, Adele, and good evening, everybody. And thank you to you as well, Adele, for the introductions. I appreciate that. As you know, my name is Rayan. You can call me Rayan, and I'll be your facilitator for this course. It's Labor Law, MRL3702, a course that I must have done as well back in those days when I was a UNISA student, which I also enjoyed, and a fair amount of which the work I do also, I do in practice, a number of labor matters and labor issues. So as Adele has said, this shouldn't be a formal lecture. This is a discussion. I'd like to hear from you as well. I would like to explore a few things this evening. One of them is just being some basic techniques to UNISA studies. Already you are at this level, it means that you must have passed MRL3701, which I believe is insolvency law. It's also another subject that I've taught at UNISA for some time, and also an area of interest for me. So to have come past insolvency law, you already must have done a minimum of a second year or even a third year LLB course. So I hope that I will assume, as many teachers will, that you already have some basic knowledge of the workings of law, and that is very helpful, for you to understand the concepts that we're going to discuss. But even if you do not understand, that is the whole point of these exercises and meetings, is that we come together and we can talk. And it's the difficulty is that subjects are compartmentalized. The LLB degree is 40 modules, 40 subjects basically, which equals your LLB degree. And how you complete that is basically part of our talk tonight. If you just see the LLB degree as simply 40 subjects, 40 university subjects that you need to acquire over a certain period, rather than this big thing that some of us mentally put in our minds that it's a degree, it's 4 years, it's going to take so long, blah blah blah, and we make it difficult. We put a mental picture of something that's very big, but in reality, it's a lot of subjects that must be broken down. Now, granted, it is a lot of subjects, and Your challenge is going to be, when you study law, is to link up all the subjects eventually. When you started out with your fundamentals, African law, the an introduction to law, and all these introductory subjects, then it may have left you, but confused slightly for some of you, or you may have wondered, where does this fit in, where does that fit in? But it's all part of a big puzzle, which is meant to give you an understanding and a knowledge of the workings of the legal system, and a proficient one at that. If you become proficient in the material, to such a point that you are able to understand it and to use it in practical examples. So, I would like, if you guys have any questions, you can just type it up there, or you can just put up your hand and we'll take your question. So to start off, guys, I first want to, present you with an idea. I don't have my slides with me this evening, but it's an idea that I've picked up over many years of study at UNISA, being my alma mater. I graduated from and completed my degrees, and I picked up a technique which I then later used for further studies, and also giving my own students, my face-to-face students, my online students, this suggestion, that what I found is when I ask people how they approach their studies, what is their technique? Many students use a technique which is pretty piecemeal. So for this subject, for example, you'll notice it is divided into two areas, two major divisions in it: individual labor law and collective labor law. These are the two divisions, and they're going to examine you on both of these. Now, many students will, when they first get the material, they will try and acquire the textbook, get the study guides, letters and everything, and they will work out the program being, okay, there appears to be like 20 study units here or 15 study units here. Let's break it down. And let's see, if I can complete study unit 1 and 2 for the next 2 weeks, and then study units 3 to 4 or 5 in the following week, and so on and so on and so on. And hopefully the idea is going to be that before they reach, they will try and cover all the units before the exam comes, so that they can prepare for the exam. And the problem with that approach is that many times, what are you going to do if, for example, you get ill, or you can't finish the work, or for some reason something happens and you're not able to come to the end of it? So you've got a good understanding of the first 1 or 2 or 3 learning units, but you've got no idea where what the last few units are about. So, for example, in this course, a large part of the course is, I would say, maybe 60%. The majority of the course is individual labor law, and you may be focusing on that so intensely. Types of the differences between an employee and an independent contractor, the various tests, the presumptions that have been introduced, the categories of employees, is all parts of individual labor law. Vicarious liability, restraint of trade clauses, and so these are all these units in the beginning. So we tend to focus on them, and we're spending all our attention on them. To the basic conditions of employment act, Employment Equity Act, social security legislation, unfair dismissal, unfair labor practices. So we spend so much time on this, but we then perhaps may not even come to the other major part of the subject, which is in the collective labor law. Okay? So you know very little about it when you eventually, when you come towards the end of the studies and you realize, okay, I'm going to write an exam. I don't have much knowledge of what's going on in collective labor law. So pretty much that's what happens, and it creates a lot of panic. People don't finish it, or they finish it superficially. Okay. Now, my suggestion to you guys is that instead of doing that, why don't you take you must try and get an understanding of how, what they are trying to teach you in the entire course. And every tutorial letter at UNISA, they tell you the purpose of this course is to teach you the basics of labor law, both in the individual labor law, the collective labor law, and to be able to learn it in such a way that you can apply the principles and use it in practical examples. So that being the case now, that you must now acquire that knowledge, you must now look at the entire course and ask yourself, what exactly are they trying to teach me? Right? So if they make those statements that we're trying to teach you this, you must get a grasp of the whole thing, not these small pieces at a time. If you've got lots of time on your hands, if you've got an extended semester, which we don't have, this is a year, a semesterized course. It used to be a year course. The days that was written before, it used to be over a period of 1 year, one academic year rather than 2 semesters when I studied. So we don't have that time. Okay? We've got like less than or just about 3 months to cover what was once a year course. And we have 2 hours in our exams to write a paper that is out of 100 marks. Of course, I can understand that the way they have examined students, they don't use the technique that they used in our days, which was asking you these very long, discussion questions and essay type questions, short questions, but requiring long, long answers. Okay, like 20 mark questions, 25 mark questions. Now that has also changed. Okay. Question papers now are quite long. They ask you many, many questions in your question paper. The mark allocations are a lot shorter. You hardly find a question even that's 10 marks. It's like very short questions, but they testing you in a very different way than what they used to test. So the whole teaching has also changed, and this is what you must understand, that the teachers at UNISA, the lecturers, have many, many students. Okay, they must teach university level courses to students who over a certain period, and they can't. If there's so many students, there are far more students than the residential universities who hold classes physically face to face. So if all the students have a query, it will be, and they had to do it in the way that they used to do it, they wouldn't be able to do it. Even if 1,000 students send you an email, which is more or less about the same thing, you won't be able to deal with it so easily, right? So they have to now give you everything. The course that they present has to be sort of in a box, a presentation that is labeled. These are your perimeters. These are the limits of the course. The course will be those few chapters here or those learning units here. Okay, so this is what I'm trying to say. You must like that, and that is times 40, guys. There's 40 subjects for the LLB. So in each subject, courses are presented like that. And so you must understand what the limits are, where you're required, your learning scope is, ends, so that you can plan. Because this is what you need to do. You need to plan. Okay, for MRL3702, I've got to complete individual labor law and collective labor law. It's like 7 or 8 chapters in individual labor law, and there are like 5 or 6 chapters in collective labor law. Then one thing you should do is you should prepare an outline of the course. Write down the main chapters in each, the main subheadings in each chapter. Okay, and get the bird's overview of everything. I like to use a mind map. I like to put it sort of diagrammatically on one page. If you can condense the entire course in one page, in other words, not the content now, you won't be able to do that on one page, but what it is that the broad content of this course. It is an excellent reminder for you to always go back and to look at and to refer to when you prepare and you start your studies on the course. So, for example, individual labor law, the differences between an employee, the old definitions, the common law. Okay, that's perhaps learning unit 1 and 2. Learning unit 3 is basic conditions of employment act. Learning unit 4 is employment equity. Learning unit 5, for example, is social security legislation. Learning unit 6 could be the unfair dismissal, termination of employment. So all lengthy chapters, but at least you should know where you're going to start and where you're going to end. And if you do that, that is what you should outline. Now, what I'm suggesting to you guys is that instead of making small notes or even whatever notes you make as you go on learning unit per week or per 2 weeks, rather go through everything at once. Complete what I would call a cycle. Once you made that diagram, that bird's eye view, that outline on one page, you go through the material once, complete what I call a first cycle, because this will now give you an idea as to what you need to cover, what they're trying to teach you there, from the beginning till the end. And in your first cycle, you're not going to make sense of everything. I mean, unless you're some kind of mind guru or you've got this ability to absorb information like that. But it's not so with law, with the complex concepts that are explained in every chapter. So you must, go through your first cycle. And in your first cycle, you make a skeleton of every chapter. That should put you, it might frighten some people. They may feel, no, I want to go back to my old method of doing things, like learning unit 1, 2 in the first week. But if you persevere and you continue in your second cycle, which you will go through again, you start adding notes to the skeleton that you've now created in your first cycle. Okay. The idea is, guys, that instead of going piece by piece, that you go through the work regularly, you complete cycles, and to complete as many cycles as you can in order to gain mastery in the course. And this technique has worked for me, but don't take my word for it. There's many of my students over the years have, tried the technique, and the technique seems to work for them. Many students have come saying, look, passed very well, we've got our distinctions. It was daunting at first because we wondered whether, how can we go on from chapter or learning unit 1 and 2, but we don't even understand, how can we go to the next learning unit when we don't understand the one that we're busy with? The idea is that you are going to always come back to it, that you're going to go in, you're going to go past it, and it will start to make sense the more times that you go through it. So it's a technique I've used, and I hope you guys, would be brave enough to try it. What do you think? Nice, some Kelo, and is it Ambrose? Trying to see the names, you guys. You can just see. Can you hear me, guys?
Yes, we can hear you.
Okay. So this is my suggestion on an approach to the subject. What do you think of it? Do you think it's something that you would try?
Absolutely, yes. I think it's a method that one could try. Definitely gonna give it the best I can.
Yeah, try it, and see how it goes. Now, another thing that you could add, okay, guys, the thing is, there is definitely some kind of dedication, some kind of commitment that you're going to have, that it's required from your side towards your study. And that is why I'm saying, because if we're going to space ourselves like many people do, 1 week I'm going to finish learning units 1 to 3, whatever the case may be, then because, many times people work at a timetable and is a distance between these sessions, there's a time period, time distance between the times that they come back to their work from where they last started. And that distance, it takes away your focus, takes away what the information that you try to remember. And therefore, how can you keep the information in your mind fresh? How can you be reminded of all these concepts? Now, in addition to the method that I've mentioned now, guys, you are supposed to go through the material every cycle, right? And to add more and more notes as you go along. As you go along, you add in, until you've created like a very broad and a collection of notes on the work that makes sense to you now. It should make sense to you now. So how can you? Remember I told you you've got your schedule or your plan, your diagram on the wall, and you're adding this information. Now, in addition to this, what I found is also that, you know, because we are more prone, I mean, the teaching method of many people is to give you information. Okay, people will tell you, you know, for vicarious liability, it will be the following requirements. This is what it is. Yeah. So now, if I tell you that tonight, you may remember it tonight, some of you, but by Saturday morning, you may easily forget it. You know, what can you do to remember and retain information? Okay, you made your notes on the things. Yes, you can go read your notes, of course, and that might refresh your memory. And that is what you need to keep. You need to keep refreshing your memory. There's another method that I would suggest to you. That instead of only making notes, guys, when you make notes, rather, why don't you write down your notes in the form of questions with the answers to it? Okay. When somebody asks you a question, you know, it does two things. It really forces you now to search for an answer. Whereas if I tell you something, you don't feel any obligation towards it. You don't feel any necessity perhaps to keep it at that point. But if asked the question, you know, and once you understand what the question is, your mind is going to start to wander to give and to come up with an answer. So what is a very good method of study is to create these, what I call study question and answer cards. You know, you write down the question on one side, on the other side, you give your answer. And you keep it in these handy stacks of whatever you can keep it on, write it on. And it is always there to refresh your memory. And to refresh your memory, not only by reading notes, but by asking questions, and then the answers are nearby. Okay. And then you start to develop that memory, that retention of the information much better and much longer. And it also prepares you for the exam. Guys, what are you going to get in the exam anyway? At the end of the day, when you enter the exam room or whatever format they're going to assess you, they're going to present you with a question paper once again, right? Asking you various questions to test you. Now, if you've been doing that exercise for weeks, many weeks, the giving of answers will become easier and be almost like second nature. Okay. Many people don't study in that matter. They read information, which, you know, but they don't ask the questions. They don't phrase it in such a way or formulate it in such a way that it is a question. And if it is formulated in that way, in the form of a question, then you, like I say, will retain it much longer. So developing that muscle memory to keep you ready when you're presented with the ultimate questions in the exam. Okay, guys, are there any questions? You guys are rather quiet there. I see this is not only a talking session for me, but I would like to hear from you guys. Does anybody want to say anything or make a comment?
Now, I just wanted to say I totally agree with you on those study methods of revising and constantly keeping on revising and asking it in question form. So what I've done is I've written out every study unit. I've written out questions and answers to it, and then before I go to the next study unit, I go from the beginning and ask all those questions and answer all those questions until I get to the study unit that I'm about to do, and then I start with that one. And as I start with the new study unit, I start with having revised everything from the beginning already.
Excellent. And how long have you adopted this method?
So I started this method beginning of third year, yeah.
Okay, awesome. I can assure you, man, you're gonna do well with that method. I mean, have you already written any tests with using that method, or have you done anything? I mean, have you had a chance to write a test? If you did it this year, then you probably haven't had a chance to.
No, I haven't had the chance to yet, but in November should be able to now.
No, sure. That's great. What you should also do in addition to your own questions, I mean, because your mind is already attuned to answering questions, is once you've mastered, once you've mastered your own material, that you've now prepared your own questions and answers, is to work through old exam papers. You know, there's many of the older exam papers as you can get, and test yourself now. Once you feel that you're ready, you've gone through this exercise and retained it, then you can use that same skill now with previous exam papers, and just to see how well you do, you know. And that technique, I said, it's many students have come back to me, achieving good results with that technique. Guys, is there anything else? I was just looking at assignment. Some questions in the assignment. Quickly look at. I can't show you things here, guys, but let me see what I can gather from this here. Have you guys managed to get the textbook?
I'm currently working off of a friend's one, but I'm hopefully getting a E1, ebook one.
That's fine. Look, there are many labor law textbooks, okay, for students. The one, if you guys have the one by Christoph Garbers, which one is it that's recommended for this course?
It's Basson. It's the Basson one that's for this course.
Okay, Basson. Okay. Yeah. So let's play around with some questions here. I see here this thing over here. Here's a nice question, and I want to hear how you would answer that. You are already second year and so on. How many marks is that? I'm going to post a question here now. We can discuss that question. Okay? And hopefully it will shed some light on this area if you're having difficulty with it. Okay. Who can answer this question? This was in the assignment. The doctrine of vicarious liability. Does anybody know what this is? Would like to try and answer it. Let's discuss it. What is vicarious liability?
Isn't vicarious liability protection of third parties? And yeah, the compensation of those who suffered damages as a result of wrongful conduct of its employees, or
yes.
based on that.
It's a species of that, yes. Okay, no problem. Whoever that was, they were in the wrong module. Okay, there's a few people that were in the wrong module. Okay. No worries. Yeah, who knows what a delict is? If you guys haven't done the law of delict yet, eh? The law of delict.
I think that's one of my, that is one of my courses. Not I think, that is one of my courses for this semester.
Right. Okay, in your third year, perhaps fourth year, or your more senior years, you're going to come across, the law of obligations. Right? That is how it is structured by academics and teachers of law, that the law of obligations, the obligations are juristic bonds to which the law will attach consequences to, right? What connects you? So a contract is an example of an obligation, right? A juristic bond. We hold you to what you say. If you say it in a particular context, That is, if you decide to enter into an agreement and you both intend to agree, to bind yourselves, that it will be a contract. And if there's a valid contract in place, then there will be consequences. Okay, so that is how the law of contract is approached. In the same family there, under obligations, is also the law of delict. Okay, which is also about obligations, where we don't hold your words, we don't attach consequences. The law doesn't attach consequences to your words only, but also consequences to certain deeds that you commit. Okay, from the study of criminal law, you know what is criminal liability. What is a crime? You know, this is to understand what a delict is. We must compare these two: a crime and a delict.
A delict is I know I'm not answering that the crime question, but a delict is the act of a person that in a wrongful and culpable way causes harm to another. So that is a delict. And then I believe a crime would be an act of a person in a wrongful way or culpable way that causes harm to another, but in the public law sphere, not the private law sphere.
Yes, exactly. That is one of the main features. Okay. Same things that you said now, guys, that it's something that it is both acts, wrongful acts. Okay. When you do something that's wrong, let's use a very practical example. Okay, to demonstrate the difference between a crime and a delict. Because this is where vicarious liability comes in. If we understand this, then we'll understand vicarious liability. So a crime, let's just say you are driving your motor vehicle, you've been drinking too much, you've had too much to drink, you know, and you're driving around at night without your safety belt, and you collide, approaching an intersection, traffic light is red, and you collide into the vehicle that is stationed at the red traffic light, waiting for the light to change, and you collide straight into the rear of that vehicle. A number of things have happened. You've damaged the car of the other person, not to mention your own car. You have the person is also herself or himself also been hurt because of this accident, and it's all because of you now. Okay. Now, what kind of actions have happened here? Was there any crime committed here in that scenario?
I believe a delict would have been committed, not a crime that both, if I'm not mistaken.
Yeah, kind of both, right? The first thing, let's just think about it. Is it not a crime to be driving with your blood alcohol limit above a certain amount, or to be driving while drunk?
Is a crime.
Right, that is a crime. So the police arrive at the scene, having been called out, and they suspect that you are drunk, and they take you away. They do a breathalyzer test. They take you away for a blood sample, and it's found. That goes away for testing now. So you're well on your way to be charged. Okay, and that is the criminal process. That is a crime that was committed. You now will be arrested, possibly. You will be brought before court. All the criminal law rights, for those of you who've done criminal law and criminal procedure, will know that all these rights now kick in. All these systems kick in because it is an act that you've committed, which is against the state. Right. And you now need to you'll go through all those consequences. And that makes the person who you collided into very happy because you've done something wrong, and now the state will even take care of that. They're going to charge you. They're going to, all your rights also come up. Okay, you have the right to all those criminal rights, not to make a statement, not to remain silent, to challenge it, to challenge the evidence, because the state must now, what must the state do now to be successful against you, to find you? They must convict you, not so in the criminal system, and they've got to prove it. And what is the onus of proof in proving that? What must the state prove? The state must prove all these things. The state must prove you committed this crime. But the state must prove it on what onus, what duty, what burden is on the state in terms of evidence.
Beyond a reasonable doubt.
Beyond a reasonable doubt.
Okay.
Beyond a reasonable doubt. Right. So they have to be quite sure. They can't be second guessing. They have to be quite sure that in fact you've committed this crime and they've got the evidence. And if they can prove all of that, they will then eventually convict you. And once they convict you, they must determine your sentence for those things. Okay, so that is what could happen to you. If you are successful in resisting the state's charging, you and trying to convict you, and you are acquitted, then you won't be punished because the state failed to prove your guilt. This makes the driver or the other driver that was the victim driver very happy because you are now going to be facing consequences for those actions. But now, will this be enough? Can you call on the police to assist you further now as the victim? Because not only was that a crime the person committed, but now what about the damages to your car? Who is going to pay for those damages? Can the victim now call upon the police to request the police to arrest the person and to make demands that the person pay for the damages to the victim's vehicle? Anyone? How about the others, guys? Please feel free to participate. Huh? If you don't understand anything here, you're welcome to ask.
Yeah.
Yes.
Yeah,
Who's that speaking now? Sorry, who's speaking now?
It's Ramo was speaking.
Okay, yes, Ramo, please go ahead.
Yeah, I understand if now the police failed on the part of trial. Now there is an issue of third-party claims between the two drivers.
Yes. So will the police be able to help you now to get that money out of the drunken driver now to pay for the damages?
No, the police, they investigate criminal cases. They don't investigate civil cases.
Right. So what must that person do now? What must that victim do? Because
No,
the police.
The issue is that now the two insurance, the insurance parties then of the both drivers, then the other one who's guilty, then the other one will be claiming to the other party.
Yeah. Okay. Yeah. Quite right. The thing is, the police won't be able to help you any further than that because that is not a criminal matter. You would then have to take matters upon yourself. You would have to sue the wrongdoer in the civil courts. And what would be the grounds that you would sue them? It would be a delict. It would be particularly negligence. Okay. So you would sue that person in its victual claim, and you would have to take action in the private capacity in the civil. But like you say there, sir, if the person had insurance, right? If they didn't have insurance, then that wouldn't arise. There would be no further relief. You would have to do this privately, and out of your own pocket, take the person to court. But if the parties were insured, then it is possible that you could claim this from your own insurer. The victim could claim it from her own insurer or from the insurer of the aggressor, of the person who committed the deed. Yeah, and that is also, only for damages to the vehicle. All right. What happened if she had to break a neck or to break a leg or something? Who would be paying for that? That is also a delict, of course, but now will she be able to claim that, through the civil courts from that person? So this is what third-party litigation is, under road accident fund claims, where there's specific laws that deal with those kinds of things, where you can claim damages, injuries, or even death arising from the negligent driving of a motor vehicle And we are all car users and drivers on the road are kind of, we can't sue from people in the private capacity for injuries to our bodies. Okay, we can sue injuries to things, yes, like our cars and so on, but for our bodies and for personal injuries, bodily injuries, we have to sue that. We have to sue the road accident fund. Okay, I don't want to complicate it, guys, but that is basically your dealing there, a civil wrong. Okay, and there you must prove all of these things, not beyond reasonable doubt, but you must prove it on a balance of probabilities. In the criminal matters, the state must prove it beyond reasonable doubt. But in a civil matter like a delict or a contract, if you want somebody to pay you for damages you supposedly suffered, you need to prove it on a balance of probabilities. Now that we know what a delict is, guys, what is vicarious liability? You see, in a delict, one of the elements of a delict is that, there's a number of elements that, act that was done wrongfully and it was your fault, in the form of negligence or sometimes intention, and you caused damage. Now, in the law of delict is a doctrine known as strict liability. Okay? It's the idea that somebody else, despite you doing something or not doing something rather, you will be held responsible for the actions, as the lady had said before, for the wrong that was done, even though you didn't do it. Normally, a person is held accountable only for his own actions. But in vicarious liability, we're saying that you are going to be held liable for the acts of another person. That is possible in certain relationships. If your child does something wrong, your minor child, you as the parent may be held responsible for that. Okay. If you work for Telkom and you use the van that they give you to drive around to go and do repairs and installations, and while driving the motor vehicle, and on a job, you go and you cause an accident. You knock into someone's vehicle. So who's at fault here? On the face of it, it is the driver of the vehicle that is at fault. Yes, no doubt, he was there, he was driving the vehicle, but he was doing it in the course and scope of his employment of Telkom. And therefore, this relationship would arise now, that Telkom will be vicariously liable. It's not Telkom's fault as such, but Telkom is vicariously liable for the actions of its employees, provided that the person can show that, look, this person is employed by a Telkom, there's an employment relationship, and the person was, committed a delict. He did something wrong while he was on his duties, during the course and scope of his duties, his employer. And if you can prove that, then vicarious liability will attach. So that is the doctrine of vicarious liability. You had to do it for 6 marks. One could simply say, it's the lady that spoke earlier gave a nice description of it, but she'd had to expand on it to get 6 full marks. Okay, so it's the doctrine that in the context of employment law, labor law, that an employee or an employer, that is a boss, an employer will be held liable for the actions of its employees, for wrongful deeds that are committed, delicts committed by the employee in the course and scope of their employment. Okay? So it's not the same if that same Telkom worker gets into a fight on a Saturday night after work hours and he beats somebody up. You can't hold Telkom perhaps responsible for that, because although that is a delict and also a crime, maybe beating somebody up, also a delict because you can sue someone for damages. It's a delict as well, but it was committed outside the course and scope of his employment. Okay, so you have to prove that it was committed while he was doing his job, that you can be successful. Vicarious liability. Okay. Are there any questions on that, guys? Have you guys submitted the assignments already? When is the assignments due? The first assignment?
It's tomorrow.
Tomorrow.
Yes.
Is that so, eh? So quickly, wouldn't they have changed it?
I don't know. I speak under correction, but I think it's tomorrow.
And have you submitted
Yes,
that already?
it is tomorrow.
Have you submitted that already?
No, I'm finalizing on it.
Okay, okay, okay.
Yeah, submitting mine tonight.
Okay, and okay, there's nothing we can do it. I mean, there's anything that we can do about it right now.
I'm sure we could.
What difficulties have you had with it there? Was that a collective labor law matter or individual labor law matter? Try and get the tutorial letters.
Sorry, sorry, I didn't hear the question.
Yeah, the question is this basically for that assignment that is due, you say tomorrow. The assignment that is due tomorrow.
Yes.
Yeah. Is it a collective labor law matter or an individual labor law matter? Is it
Individual law.
Individual labor law. Is it?
Individual. Yeah. Oh no, it's collective. Sorry, the one that's due tomorrow is collective, and then the second one is individual.
Yeah, and I see that is due on next week. Next week.
End of September.
Oh, did they postpone
we
that?
We got an extension.
I see. Okay. Now, okay. Summary of the facts, the issues in dispute, order of the court, and the legal importance of the case. You've heard of the fire rack method, right? When you come to case law, when you try and take a case apart, there's a technique that you use, and it's similar to what they're asking you here for anyway. You know, so summary of facts is your facts, fire rack.
Issues, the rule application, and
the conclusion is.
Yes.
Okay. And it's so late already. Okay, how much time have we got left? We started at 5:30. We still have some time. So does anybody want to discuss this case now, or shall we perhaps open up and turn towards the next discussion? What do you guys feel we should do?
Rayan?
Yeah, yes.
Just so you know, remember you can always schedule an additional session with them if there's anything extra that you would like to take them through, eh? So
Okay,
if you want, that's absolutely to your prerogative, but you're welcome to request something like that.
Okay. Yeah, I think that's a cool idea. It will take us, look, guys. I don't know what your preparations are, but anyway, you must be able to tackle these questions anywhere along here. I mean, anywhere where you get, a question is posed in the matter, in the subject. Let me just see here. It's basically about the right to strike under what circumstances, am I correct? All right. When it all comes to these questions, guys, are you all listening to me? What you must understand, because it will, you eventually will come to this. you should come to it if you apply the study method of the cycle method. You should come to it very, very soon. But like, what is the term strike? You've heard the word strike so many times. It's actually defined in the Labor Relations Act. Section 213 deals with definitions right at the back. So right towards the end of the act, a list of definitions. Normally definitions are right in front of legislation, but this act being one of the earlier post-constitutional law acts had the definitions at the back of the act. But in any case, what does it mean to strike? Okay? When you say you're going to strike as a worker, what do you actually mean? Well, the Act defines it as, when you either completely or partially refuse to work, or you yourself refuse to work, or you obstruct others from doing work. And you're doing it with the purpose of trying to remedy a grievance that you have with your own employer. Okay. And the grievance cannot be any old grievance. It cannot be the grievance about, we want Vienna's in the free lunch that we're getting in the cafeteria. It has to be sort of a genuine dispute, and it has to be a dispute what we call a matter of mutual interest between the employer and the employee. Okay. So if there is such a legitimate grievance, and this is how the definition of strike has been put out in Section 213 of the Labor Relations Act. Okay, so when you strike, when you look at, if you consider that definition, it sounds like you're breaking, you are in violation of the contract of employment, because one of your duties under an employment contract is to render services to your employer. As long as your employer gives you a legitimate and lawful instruction, you are obliged to obey it and to follow it through. Refusing to take an instruction or to carry out works, legitimate one, you could be held liable. That could be considered misconduct, right? Which is a ground of dismissal. You'll recall, if you start to go through, do the cycle method, that misconduct, you can only dismiss somebody in our law on 3 basic grounds: misconduct, incapacity, and operational requirements. So that when you refuse to work, where you refuse or you stop others from working, on the very face of it appears to be a breach of the agreement. But the Constitution, as well as the Labor Relations Act, basically guarantees you this right that you can do it. Now, how is it possible that the law can actually constitutionally guarantee you a right to strike, okay? To refuse to work and to retard work and to stop work and to stop others from working? Okay, so those of you who's done constitutional law, administrative law, will know that not all rights, even from introductory law courses, not all rights are absolute. All rights are limited. Okay, the Constitution itself in the Bill of Rights has a limitation clause, right? And it says that the rights in this Bill of Rights, which even includes these labor law rights, can be limited, okay, to the extent of general application, and it must be reasonable. It mustn't be unnecessary or unnecessarily restrictive, but it can be limited nonetheless. And who has the right to? Who finally decides how far, if a right may be limited, number one, and to what extent it may be limited, number two, is, as you should know, the Constitutional Court. The High Court will first hear the matter, and then later on it could be sent to the Constitutional Court for confirmation. Okay, so on the one hand, you have that right now, okay, to strike under law. And the right to strike, although it looks so extreme, if an employer decides to dismiss an employee for striking, and remember, striking must be in that definition of striking. It cannot be sort of your, just haphazard, disorganized rallying or picketing or going on. It must be within that definition. If you are within that definition doing that, striking, and an employer decides to dismiss you or to take steps against you, striking or joining up with strikers, associating with strikers, then the employer will be in a lot of trouble. Because to dismiss somebody merely for participating in a strike, as long as the strike is lawful, of course, like I've told you, then it is an automatically unfair dismissal, which is one of the costly kind of things for any employer. Okay, so just to make it very clear that when you see people striking, they may not, we don't know what if we know what the background is and we are aware that there is an order, it's a lawful strike, then they are actually acting lawfully. Okay, they're not acting unlawfully. And if an employer tries to punish you or prejudice you, treat you any differently for simply striking, which is a loose form of your right to associate basically with other people, to form groups, to exercise your right, then the employer can be taken to task for that and be ordered to pay you. And when in any, there's a number of what we call automatically unfair dismissals, which are quite severe in penalty. When you go to the CCMA for a matter, the courts, in terms of the LRA, a court is normally, well, an arbitrator is normally permitted to make compensation for up to 12 months salary and whatever other benefits. It can make that compensatory order or the reinstatement of previous benefits unpaid. But in automatically unfair dismissals, then you can be expected to pay double that, up to 24 months remuneration. So employers would be well advised not to dismiss workers who are on a strike. Okay. So if that is the protection given to workers, workers want to make sure that that they're on the right side of the law, because you don't want to go on strike and then find out, well, it's not a proper strike. And there's certain conditions that must be met before they can actually, invoke this right of the right to strike. And if they then fail to do that, then of course, employer can take steps, disciplinary steps against them. Okay, if they haven't followed the steps that they need to take. And on the other spectrum, again, the employer can also, the employee's ultimate weapon is to go on a strike. The consequences of that can be devastating for some employers. Right? If your workforce remains out and you can't keep up with business, and they can create trouble. So what can an employer do? Okay, an employer can invoke what we call a lockout of the employees. And this is basically when an employer excludes these employers from the workplace. He locks them out. Okay. Because the idea is that these two parties must actually come to an agreement. Remember, you can strike when you've got a legitimate grievance about a mutual, a matter of mutual interest. Okay. And typically a matter of mutual interest is wages. Okay. Working conditions may not fall under that, but wages is very commonly an issue of mutual interest to both the employee and the employer. So, and this is how this what can I call it? I can call it a lock, or a locking in of horns. Like, if you don't pay us more, we're not going to work. Well, if you're not going to work, I'm going to not let you come in here, and I can get other people to work here. You can't interfere with them. Is basically what those two conflicting rights appear to be saying. So you can't also just as an employee go and freely go on strike as you like. it has to be in the context of what we call collective bargaining, where employees are required to organize themselves into trade unions and representatives. Might sound easy, but in a workplace where there are many thousands of employees, and not everybody wants to be a member of perhaps the majority union. Okay, and some want to do their own thing. Some may not even want to become a part of the trade unions, and have money taken from the salaries every month. Okay, but there is advantage in being formally registered as a trade union, because now, once you do that, the Labour Relations Act gives you formal recognition, excuse me, as a bargaining party with the employer, and then you can then become a party whose word is valid and who may rely on the right to strike if it ever should go that way. So this dynamic between the strike action on the one hand by the employees and the lockout by the employers on the other is how our legal structure in the labor market is set up. Okay, I have many friends who ask me, not from this country, who ask, then why can't you guys come to an agreement? And in the working world, okay, the employers and the employees know it's not always in their best interest to strike. Okay, it harms sometimes both of the parties, so they better come to an agreement as soon as they can. And but in many industries, they've sort of regulated it to such a point where every year when increase comes up, they sign agreements known as collective agreements, which has been signed by the unions and the employers or the employers' organizations. And they agree on many things in that collective agreement, and sometimes they'll also agree that, look, wages will go up to this point for the next few years. We'll come and revisit it again, whatever the case may be. Okay, and this process is called collective bargaining. Okay. Now, when then can exactly, we heard the definition in terms of Section 213 of the Labour Relations Act, but there are also cases when you cannot strike. Okay, when employees cannot go on strike and they are prohibited, in terms of law. Now, the Labour Relations Act deals with this question of when you can strike and when you can't strike. We know what the strike is defined as in terms of Section 213, but Section 64 to 68 of the LRA deals with how strikes, when strikes can be held and when they can't be held. Okay, so you just need to consider when exactly can you rely on when can you, when can't you strike. Well, firstly, if you've agreed not to strike, okay, you've signed in the collective agreement in many cases, right? That's the agreement between the employers' organizations, the employer in a particular case, and the major union, the representative union, trade union. And those collective agreements will bind all the other employees under that agreement. So if they've agreed in the collective agreement that we won't strike during certain times or certain conditions, in that strike, then they cannot actually go on strike. Although one could argue now that how can we agree in a collective agreement not to strike when that is a constitutional right to strike? How can we have something like that? So an agreement like that will be very narrow. There is a court case on that about clauses like that in collective agreement. It cannot be permitted, that to have such a clause that we agree not to strike. The courts have said that this must be sort of very narrowly interpreted, and it cannot be something that obviously is indefinite. Okay. You could also, in your collective agreement, say, well, if we have a dispute, we're not going to resolve to striking. We're first going to resolve it to arbitration. Okay. So, for example, when a dispute of mutual interest arises, and the parties will now want to start the process. Let's say it's about wages or some other issue of mutual interest. Many times the collective agreements will, and like many agreements generally do state that, look, when we have a problem, we're going to try and resolve it through arbitration. So raising the point that, you know, you can't go to litigation, which is going to court formally before you try and resolve it in arbitration, is a valid defense. Not only in labor laws, but also in other civil litigation. You know, if somebody sues you, your landlord sues you and says, well, and he issues a summons and you defend the summons, plead to the summons, and you say in the summons, look, in our agreement, we said that we won't immediately go to court. We're first going to try and resolve it through arbitration. And you want the matter to be resolved through arbitration, so the matter can be paused in court, put on hold in court until it gets resolved at arbitration. So in those instances, and now this is now by law now, this is what the LRA is saying. So you can't strike when a collective agreement is prohibited in some instances, when it has to be resolved by arbitration, where the act itself says in certain instances you can't resolve it through arbitration, but it must go to the labor court. People that also cannot strike are people who work what we call essential workers. You know, you must have seen a lot of these now with COVID. The doctors and the nurses and the safety and health people and, you know, essential maintenance people. Their rights to strike are limited in terms of law. So they can't just run to the streets, that kind of thing. But they get, you know, other particular rights again to suit their particular difficulty. So if the parties or if the employees decide, you know, notwithstanding those provisions of the LRA to go ahead with the strike, and that strike would be unprotected. It would be an unlawful strike. Okay, and that would now raise a lot of issues and sort of options to the employer now, because if you are striking and the LRA forbids it, or a collective agreement may forbid it, or you're not following the proper process, you don't go to arbitration or whatever, then you are in an unprotected strike. And an unprotected strike doesn't have the protection of the labor law rights. And you could now be an employee who is, you know, committing an act of misconduct. And typically what would happen there is that you would be called to a disciplinary hearing. They'll give you a disciplinary notice, come and attend the disciplinary hearing while you are on your supposedly lawful strike. So the worker should be aware of the fact that, you know, they don't want to go out while the strike is unprotected. You could also interdict such a strike as an employer. Okay, an interdict is going to court for a court order and asking the court to declare that strike unlawful. And that would automatically, if that was successful, put the workers in a bad position now, and the trade unions in a bad position. So what does one then have to do to have the strike, you know, be like a lawful strike? And because once there is a lawful strike, then only can the employer lawfully lock out the employees. All right. If the strike is unlawful, then it is you unprotected, and all the other rights of the employer come into play, as I've just mentioned now, disciplinary action and so on. So to have your strike be made lawful, there's a procedure you must follow. Okay. So I think, guys, maybe we can you know, I can continue this discussion. I see it's 5 to 7 now. It is quite a lengthy subject, and I'm just speaking on it so, you know, randomly like this. I'm suggesting to you that you continue with the cycle approach to it, you know, going through the work as much as you can. And where you are coming across difficulties, make a note of it, and then we can definitely discuss that here. Okay? These are collective labor law points I'm raising, and it's a good idea to start with your individual labor law, your basic rights of employment, to understand what it is. Right. Are there any questions? Because I've spoken now so long, nobody's saying anything.
Excuse me.
Yes.
How often will we have these meetings? Yeah.
As often, you can tell me now. Sorry, is your name? I'm just trying to look for the names. Sorry,
Kenneth.
sir. Kenneth.
Yes.
Kenneth Morris.
That's correct, sir.
Okay. Kenneth, we can have them. The idea you heard Adele. Adele said, look, you guys can contact me now and you can arrange a session with me from next week. From next week, you're supposed to have this once a week, but now if you feel that, look, you need help with a certain area, you can book a session with me from next week onward. And then we can work out the time. Doesn't always have to be this time. This is a bit late in the evening. I do it 3 times a week, at least. But, sometimes the weekends may work for you. Maybe not also. Or, earlier time. So from next week, Monday, I hope I should get my full access rights to UNISA teams, and then I can arrange with you guys.
Thank you very much.
Okay, I don't know if what I've said is you found helpful in any way, but the idea is the more you prepare, the more you would, we would get a better understanding of what we discuss in the class today.
I think it's very, very
Rian.
This is one
Lugano.
Oh, sorry.
Sorry, Kenneth. One second, Kenneth.
Okay.
Let us hear from Lugano. Yeah.
No, I just wanted to ask quick. Do we get in contact with you via the email address, or how do we get in contact with you to book a space for next week?
Yeah. Adele, are you perhaps there? Can you perhaps shed light on that? Adele? Okay, Adele is probably busy somewhere. But I would say to you now, how did you find out? How did you get connected here this evening? Was there an email that was going out?
Yes, there was.
Okay. Because, until next week, I don't have the full access rights to Teams. And that is why I can't, do all these other things that I normally do on Blackboard and Zoom and, so from next week I'll get that. But please speak to Adele. Adele, she's the person that's organizing this, and then, mention to her, I believe there's a central point where you can send requests that you guys want further sessions, and then we can have those sessions.
Thank you.
Okay. Until next week, when I get my full access, then we don't have to go through them. We can do it, as it may be convenient to us.
Thanks, Rian. Really appreciate it.
Yeah. Cool,
Students,
man.
again, don't forget to complete the attendance register and the feedback form. Please don't forget, eh?
Adele, have you heard the students' questions? They want to know when they can book further sessions and how they go about that.
Okay. Rayan, they can, in the meantime, if you want to give them your email address, submit queries to you. You can do that, but that's an interim measure. I think by next week, early next week, we'll be ready, unless you want to wait until then for our Teams platform for the consultations to be ready. So it's absolutely your choice.
No, we'll wait till next week, Adele. I've just mentioned that to them as well.
Yes.
That I would prefer, getting the full proper access. Then we don't have to. Then we can be free to arrange the times, and without any hurdles or difficulties or issues.
Yeah, and I'd like to stay away from emails. Sometimes are just time consuming.
Absolutely.
Yeah.
I get literally hundreds of days, so
exactly.
I can't actually. It won't be fair to students actually. I can't respond to everybody.
Yeah. Okay. No good. Then we'll wait till next week.
Okay, then now. Okay, students, thank you for that. We'll meet next week again. Okay. Thank you, Adele.
Thank you, Ryan.
Bye,
Have a
Adam.
lovely evening,
You
everyone.
too.
Bye.
Bye.